All right, let me set up the situation for you. Real estate agent conducts an open house, buyers come in. And one particular buyer, as they're walking through the property and they're looking around, they don't notice that there is a 6-inch step in the hallway because the hardwood floor on top of the step matches the hardwood floor below the step and it camouflages the step. So as the buyer's walking through and they're looking around or maybe looking at the fact sheet, the brochure about the property, they don't see the step and they don't anticipate the drop. They step down, fracture their ankle. With that buyer now injured, they want to sue. So they're going to sue the real estate agent, the brokerage, and the seller. So, who wins? Now, believe it or not, this exact lawsuit has happened in a lot of different states. It doesn't involve real estate law per se. This is actually personal injury law, and specifically premises liability. So in this type of situation, the buyer is going to go retain an attorney who has a focus in premises liability. And they are going to make certain arguments. And the real estate agent or brokerage would be well advised to find themselves a defense attorney that has a knack for premises liability. And a premises liability lawsuit, there's a lot of different issues that the attorneys are going to argue. So it's important to understand what the law actually requires. In order to incur liability for an injury that happened on the premises, you need to either be a property owner or have sufficient control or possession of the property. Sometimes the law refers to this as occupation of the property. That is, you have to sufficiently occupy the property in order for liability to be attached. So let's take a look at what the arguments would be on both sides of this case. Buyer's attorney is going to argue that the buyer was invited in to look at the home while the agent had full control of the property. Therefore, the agent had a legal duty to warn the buyer of inherent risks and dangers within the house. The step was not open and obvious, it was camouflaged. And a buyer walking through the property looking at the space within it cannot be expected to notice a 6-inch step that blends itself within the flooring. The agent was therefore liable for not warning the buyer of the step. Now, on the flip side, the agent's attorney is going to argue that the agent was not the owner of the land, nor was he in adequate occupation of the property. Therefore, the agent had no duty to ensure the safety of the buyer at all. However, even if the agent was a possessor of the property for the law to impose a duty to warn the buyer, the step was open and obvious within the home and posed no clear and present danger. The agent cannot be expected to warn the buyer over every little possible danger within the home because that would pose an unreasonable burden on the agent. Because the step was not an inherent danger, was open and obvious, the agent owed no duty to warn the buyer of the step. All right, so as you can see, the arguments are going to hone in on a couple key issues. The first being whether the agent had a duty to warn because they were in sufficient control or they occupied the property to the same degree as an owner does. Therefore, just as an owner has a duty to warn invitees about dangers on the property, the agent does too. The other issue that's going to be argued is if it is clear that the agent had a duty because they controlled the property to that degree, well, did they then have a duty to warn about the step? That is the step an inherent danger within the property? Or is it so open and obvious that the agent had no duty to warn? So what do you think? If you were the judge and this case came before you, how would you rule? Well, as I mentioned, this has happened in a lot of different states. A lot of court cases out there, and we're going to take a look at one. One that happened in New Jersey where this was nearly identical to what happened in that case. There was a step within a room, and there was vinyl flooring on top of the step, vinyl flooring below the step, and it caused the buyer to not see the step, and she stepped off and ended up fracturing her ankle. So she sued. Let's take a look at what the court determined in that case. The court first analyzes the law in regard to an owner and a possessor of property, both having a duty to warn invitees on the property of inherent risks and dangers. But then the court looks specifically at the real estate agent or broker and a prospective buyer and that relationship. And the court finds this. In sum, the nature of the relationship between a real estate broker and its customer in the conduct of an open house inspection of property is substantial. The relationship confers certain specific benefits on the broker and creates expectations on the part of the customer with respect to the broker's professional services. Based on the nature and circumstances surrounding an open house, we conclude that implicit in the broker's invitation to customers is some commensurate degree of responsibility for their safety while visiting the premises. So in essence, the court is saying, look, agents, brokers, when you hold an open house, you are standing to economically gain from people who come onto the property, right? They're going to possibly buy it and you're going to receive a commission. So the benefits you gain are definitely noteworthy. Now, in turn, as a customer comes on the property, they are expecting certain things of you as a real estate professional. Now, based on the circumstances of an open house, where they come into the property and they're not all that familiar with it, you have some degree of familiarity with it, and the fact that you invited them into the property, you now have some degree of responsibility for their safety. So what is that responsibility? Well, let's take a look at what the court held. The court held that a real estate broker has a duty to ensure through reasonable inspection and warning the safety of prospective buyers and visitors who tour an open house. The duty to conduct a reasonable inspection in the home arises when, in connection with an open house tour, such an inspection is a part of the professional services that would be undertaken by a reasonable broker in attempting to sell the house on behalf of its owner, and when the broker has had an adequate opportunity to have undertaken that inspection. The scope of the duty to inspect and warn is limited only to defects that are reasonably discoverable through an ordinary inspection of the home undertaken for purposes of its potential sale. All right, so the court determines that a real estate agent has a duty to perform a reasonable inspection of the home before holding the open house. Now, what does that mean? What kind of inspection? Well, the court says that the inspection is limited to what would be required to sell the property. Now, does that mean that the agent now has to become a home inspector and check the furnace and check the structure and the roof and all of those things? Well, that was the interpretation of one of the justices on the New Jersey Supreme Court, and they said, hey, this is a pretty big deal that you're requiring these agents to go out and perform all of these elaborate inspections. The court tries to be clear with its answer and say, no, you're going to just do a basic inspection to see the overall condition of the property. And if you're holding an open house and you're inviting people in, well, we think that you should also take a look around to make sure there's no inherent risks where people could be injured as they're going around this property. The court says we don't think that's that big of a burden on the agent. So therefore, that's our holding. As a real estate agent holding an open house, you got to take a look around and check for any pitfalls or dangers that somebody might get injured on upon going through the premises. Now, the court is not saying that the agent had to guarantee the buyer's safety as they go through the property, but the court said you must make a reasonable inspection of the property to look for basic problems that could cause an injury. All right, so what do you think about that decision? Do you agree with it? Or do you agree with the agent and their defense that, hey, it's not our property, and this step was open and obvious, so we really shouldn't have this duty to go around looking for everything and warning people as they come through the home? Well, the nuances of the law and the facts could create a different outcome and vary state to state. So as always, if you find yourself in a similar situation, always consult an attorney in your area, but also understand that there are a lot of cases out there where agents have been held liable for not warning buyers in an open house of certain dangers that were present on the property, and those buyers got injured. So this isn't a one-off case or a foreign idea. There is some substance to the idea that an agent who has the property listed and is inviting buyers inside the property to show it during an open house has some responsibility and duty to warn those buyers of any dangers that might creep up and cause an injury while the buyers are touring the property. Now, sometimes agents get so wrapped up in the real estate law that they fail to understand that there's other areas of law that also touch their profession, this being one of them, premises liability. I hope you enjoyed the video and found the arguments interesting and seeing how it's not just real estate law that touches your profession, but personal injury law as well. Now make sure you talk to your broker or an attorney in the area and find out exactly what the law requires of you in your area. Drop a comment, let me know. Do you agree with the outcome in this case? And make sure that you like and share this with other agents in your office. Hit the subscribe button, turn your notifications on so that you get notified when we drop the next video. And we will see you with the next case.